Lawyers for President Trump and California Governor Gavin Newsom are clashing in court, the start of a trial with national implications. The state is suing the Trump administration, saying that they unlawfully federalized thousands of National Guard troops to quell anti-ICE protests back in June. Right now, some 300 troops are still on the ground in Los Angeles. Let's discuss with former Deputy Secretary of Homeland Security under President Trump, Ken Cuccinelli. He's now a senior fellow at the Center for Renewing America. Ken, thanks so much for being with us. So Trump's attorneys are citing Section 12406 of the U.S. Code to justify federalizing the California National Guard. Section 12406 allows for that in cases of rebellion or when regular forces can't execute U.S. laws exclusively. The judge in this case, Judge Breyer, has called the protests in June far short of rebellion. So in your eyes, how is that standard to cite this code as justification being met?
So first of all, one of the things that's a clear difference with this judge is that the president has the authority to make this on a fairly unreviewable basis. So the first remarkable thing about this case is that it is continuing onward at all. This judge has already attempted to issue a temporary restraining order, which has a much higher standard than a simple trial, as we're seeing today. So we know this judge is going to rule against the administration. The real question is what's going to happen on appeal. And the judge in the lower court, well, the judge who's sitting today, made the very point in your question, and that is he questioned the substance of the president's decision. He questioned whether there was rebellion against the United States, which the U.S. says doesn't require trying to overthrow. It just requires resisting the efforts of the United States, going all the way back to the Whiskey Rebellion, so-called rebellion. They weren't trying to overthrow George Washington as the president. They were objecting to taxes. And that is really at the very beginning of where this statute begins. Historically is in the 1790s. So I think the president on appeal is going to prevail on that, and he's going to prevail on the question of whether the court has authority to review his determination at all. Both the rebellion question and whether the forces of the United States, in this case ICE and Department of Homeland Security typically, are adequate to the task they were undertaking and are still undertaking in Los Angeles, which is even more difficult for Governor Newsom to attempt to get the court to review in terms of butting into the president's inherent authority.
I do want to ask you about the governor's role in all this, but I sort of want to get your definition of what constitutes a rebellion in this case, because I don't think that's necessarily what we saw earlier this year. There have been varying degrees of public protests throughout the country. I wonder whether, if it repeats itself, the kind of public protest that we saw in California were to happen in a red state with a future president who's a Democrat, if you would have any objection to them using the National Guard over the objections of a governor.
If you're asking would I have any objection, no, I wouldn't have any objection. I think the president is well within the boundaries of his authority here. When I was the deputy secretary at DHS, we had cities burning across the country, and the president didn't take this step. And lots of cities across America, frankly, paid for it. And the president has learned that lesson. He's not going to tolerate violence that's associated with federal activity, in this case, ICE operations. And you know, I think that's one of the lessons of the first Trump administration that we're seeing play out from the president here. Whether it's a red state or a blue state, utterly irrelevant to me. As I said back in 2020, surely we can all agree that violence is bad no matter why it happens. The reasons don't legitimize the violence, and whether it's in a red state or a blue state, to your exact point, shouldn't make any difference at all.
And yet, to try to narrow down, what is it that constitutes the difference between public protest and what in your eyes is a rebellion? Because I don't think even what we saw this year rises to the level of what we saw in 2020. And surely there was violence and there were things that crossed the line, but I don't think that at any point officials in Southern California said publicly that they thought things were completely out of their control. So why have that federal intervention if this is just public protests that they felt they could have handled?
So just to be clear, there was a point at which the police chief in LA did say that they didn't have control publicly. But is that a legal benchmark? Not necessarily, but it does give a measure of the organization behind the violence that was going on there. And you're right, this is less severe, if for no other reason than it's only one city, than what was happening in 2020. But I don't think the president has imposed upon himself the kind of threshold. I don't think he said to himself, well, if things get like 2020, then I'll do X. He is doing this on a one city basis, and he's making it very clear that he's going to support the immigration efforts, and when people organize, as they have in LA, to oppose those efforts, and those organizational efforts also include violence and violating the law, if the locality will not handle or cannot handle that escalation, then clearly the president is going to use his authority under Section 12406, as you mentioned, among other authorities, to bring in the National Guard in this case, the Marines if necessary. Both of those are consistent with the Posse Comitatus Act. Both of those are consistent with the Insurrection Act. I think on appeal, the president is going to prevail on the substance of this case. I don't think he's going to win in front of this particular judge, who, ironically enough, is the brother of Justice Breyer. But the temporary restraining order that he was willing to issue at the beginning of June, I think, tells us that he's going to rule for Governor Newsom at this level of the case.
I want to get your thoughts on something specific within the filing. California's filing says that Guard troops joined ICE on as many as 75% of their missions, including during a raid at a cannabis facility. This is according to sworn deposition from an ICE field officer. That's very different from the administration's position that these troops were there to guard federal property, is it not?
Well, I don't think they have taken only the position that they were there to guard federal property. Property was one thing in a list in the filing that I've read from the government, and their presence with ICE and was there as a protective measure. Protecting ICE agents was one of the things the government has argued, and I would point out that the statutes allow the use of National Guard much more aggressively than that. So that's a bit of a compromise position, even from what's available to the president under the law. But they've argued more than just defending property.
Lastly, I said that I would ask you about Governor Newsom. The law specifically stipulates, I should say, that orders have to be issued through governors. How does this, I mean, you know where I'm getting at. If the governor is actually opposing this decision,
yes,
how does the federal government have the authority to supersede that?
Sure. So there's two elements to that: is the notice to the governor, which is what the United States says through means, and they let the adjutant general know who is the person in California who performs this work for the governor. And the president talked to Governor Newsom the day before he issued his proclamation. I don't know the details of that conversation, but I know the government has argued that that is also part of the notice. However, the governor doesn't have to give permission for the federalization of the Guard. I looked at this when I was Virginia's Attorney General very specifically, and President Obama was the president then. I had no problem suing when he was out of bounds, but there wasn't a basis for us to sue on his federalization of the Guard, and I don't think Governor Newsom is going to do any better. The law hasn't changed in the last 10 years, and I think what's going to come out of this is really we're going to get our first Posse Comitatus court case that's meaningful in these sorts of circumstances, and it's going to solidify the president's position to utilize not just the National Guard, but also the military to support and supplement what is normally thought of as civilian law enforcement.
We'll see how the higher courts rule. Ken Cuccinelli, appreciate you sharing your point of view.